afternoon and welcome to this brief follow-up landlord and tenant webinar. Thank you for joining us on this, the hottest day of the year so far. I'm Andrew Warren, a partner in the real estate group based in the Glasgow office of Wakefields. A couple of weeks back on 11th June, we hosted a webinar where we looked at changes to provisions in leases, which we saw on the horizon post-COVID from a landlord and tenant perspective. And we also looked at lease renewals and the PACT process. As you may be aware, over the weekend, a new lease code was introduced, along with changes to the moratorium period for forfeiture in England. And that's what we're going to look at today. We've pulled together the same panel as we had for the previous webinar. We're joining me again today is Helena Leapster, a partner in our real estate group based in London. Matt Williamson, a partner based in Liverpool, who heads our retail group. And Peter Hall, who's a property litigation expert and a senior associate based in Manchester. So we're going to spread right across the country for you there today. In today's session, Peter will run through the lease code and the changes to the forfeiture moratorium period. I'll then take a look at, with a brief compare and contrast into the position of Scotland, as I did before, and we'll then wrap up with a question and answer panel session on the issues arising. The session should run for about half an hour. The usual housekeeping rules apply. So we're going to screen on that. Sound. And on issues, on sound, you can see the select the audio preference on the panel there. And on issues arising, if you have any issues, just please select the hand button on the panel and the organizer will contact you. And if you have any questions, again on the screen there, there's a box to put the questions in. So as we're at tight for time today, let's crack on and I'll pass you over to Peter. Peter.
Thanks, Andrew. So the new Code of Practice was published on Friday. It will apply until the 24th of June next year, and it applies across the whole of the UK. The most important thing to note about this Code of Practice is it is voluntary. Nothing in the Code of Practice can change any existing legal relationships between landlords and tenants or any relationships with any third parties. Essentially, it is just a guide to best practice. Now, the government has since March been urging landlords and tenants to be reasonable, negotiate with each other, and this is really just putting a bit more flesh on those bones, trying to be a bit clearer about what the government expects, albeit, as I say, it is all voluntary and non-binding. The code has been endorsed by some trade bodies such as the British Chambers of Commerce and the British Property Federation, so there has been input from both the landlord and tenant side in its drafting. It applies across all business sectors, so although there are some sectors which have of course been affected more than others, the code does apply to everybody, albeit the government does expect it will be particularly relevant to the hospitality and leisure sector and some parts of retail, which have been more badly affected than some other parts of the economy. So three main principles under the code. First one, tenants who can pay their rent in full are expected to do so. Second, tenants who cannot pay their rent in full are expected to do two things. One is to communicate with their landlords and to explain the difficulties they're having, and secondly is to pay whatever they are able to pay. And finally, landlords who are in a position to support businesses in need are expected to do so. Now, the code urges both landlords and tenants to act reasonably, swiftly, transparently, and in good faith with each other. They're also urged to support each other in any negotiations that either of them may be having with third parties, such as utility suppliers or banks. There is an express recognition in the code that any government support that may already have been received, for instance, if a tenant has furloughed staff and has received furlough payments from the government, that support isn't just intended to be earmarked for wages, but it is intended to support the tenant's business as a whole, including its ability to pay rent. So tenants who have had support from the government, regardless of what form that support takes, that is to be taken into account in assessing the tenant's ability to pay the rent. Now, parties are supposed to negotiate with each other. It may well be they don't immediately see eye to eye with each other on how things ought to be managed. So if they can't reach a meeting of minds, they are urged to consider some kind of alternative dispute resolution if appropriate. And in my view, it's only really going to be appropriate in certain high value cases. It may be appropriate to bring a third party in, but I think for most landlord and tenant relationships, that probably isn't necessarily going to help. So we talked earlier about both parties acting in good faith with each other, and really just to explain what that means is I think there is an expectation on both sides that they will disclose any information or documents that may support the stance they're taking. So tenants who are seeking support from their landlords should explain why that support is needed. If they have information about their turnover, for instance, even if that's information they wouldn't normally provide to a landlord, there is an expectation that in these unusual circumstances, tenants should provide that information so that the landlords can see exactly what position they are in. Equally, any landlords who are not meeting their tenants' expectations in terms of support, they may have good reasons themselves as to why that is. For instance, if a landlord has a bank who hasn't been helpful or cooperative, then there is an expectation that the landlord will explain this to the tenant and will provide evidence of the position that he's in. I think in both cases it's recognised that information might need to be provided on a confidential basis so that it won't be sent on to third parties who don't have a reason to see it. Now, landlords shouldn't just look at their tenants as a block, as a homogenous group. Each tenant is different potentially. Each business will have been impacted in a different way. So landlords are urged to consider the impact on each individual tenant's business. For instance, some businesses have been closed for longer than others. Different businesses have had to introduce different types of social distancing measures, some of which may be more costly and disruptive than others. We've already mentioned government support, such as the furlough scheme payments. Some tenants will have done better out of those schemes than others. It's also fair and reasonable to look at the tenant's track record. Were they a good tenant in the past? And if so, obviously then there might be a case for being more accommodating. There's also a reminder in there that some sectors, for instance, licensed premises, may have possibly other avenues, such as a pubs code arbitration. And if so, then that's something that should also be looked at in the round as well. Now, we've been advising our clients since this crisis erupted in March that really there are good reasons for landlords and tenants, if they have agreed to alter their relationship and provide some support, to get their agreement recorded in writing so that it will be clear what's been agreed and that both parties will be bound by that agreement. This is recognised expressly in the code. The aim of any negotiation is hopefully to arrive at a concession agreement, provided of course the tenant has established to the landlord's satisfaction that they deserve a concession and the landlord is in a position where they're able to agree to that. So there are various examples given in the code of concessions that landlords and tenants might consider. Now, none of this, of course, is binding. Each situation is different. Each relationship is different, but the types of concession that are suggested parties might want to consider will include a rent-free period, either a full rent-free period or a partial rent-free period. Alternatively, a deferral of rent, so the rent will still be paid in full, but the tenant will have longer to pay it than usual. There may be a permanent reduction in rent throughout the term of the lease. The parties might want to consider rescheduling payments, so rent quarterly in advance. Arguably, that's onerous. You might want to think about changing that to monthly in advance, and certainly that happened quite a lot in the last recession, and we're aware of cases where that's being agreed now. It may also be reasonable to, if you're going to monthly rents, to also consider whether it should be monthly in arrears rather than in advance. So the same rent is payable, but the tenant is given a breathing space. The parties may already have a rent deposit, so it may be that they agree that that should be drawn down upon to pay a certain amount of rent, and then the tenant either doesn't have to top it up, or they are given longer than usual in which to do so. Landlords who are entitled to default interest might want to record that they are waiving their entitlement to that, which would obviously save the parties the bother of having to calculate it. If there is a concession, then either that would need to be for a specific and defined period of time. Parties might want to consider whether there should be some trigger to that period ending, i.e. perhaps when the restrictions are lifted and we're all going back to normal. My view is I think that could be quite difficult to draft unless you have a very clear and well understood trigger for bringing the arrangement to an end. I think it may be better just to stick with a time period. At least that's clear and it's not going to lead to a further dispute. The code also recognises that in return for a concession, it might well be fair and reasonable for the landlord to be given something in return. So the parties are urged to consider whether they should be talking about a lease regear, i.e. the tenant agrees to a longer term, or to removing a break option in return for being given a concession. So there's a quid pro quo that hopefully benefits both parties. So this obviously none of this is taking place in a vacuum. It's taking place against a background where the government has introduced temporary measures which make it harder than usual for landlords to recover rent. So firstly, forfeiture for non-payment of rent under a business tenancy, that was banned until the 30th of June. That date has now been extended further, so it's now until the 30th of September. You cannot forfeit at all for non-payment of rent. You can forfeit in principle for other breaches of the lease. However, you will be caught by the general stay on possession proceedings, which applies to both business and residential tenancies. That was initially introduced until the 25th of June. That's now been extended until the 23rd of August, and there is a big backlog of work building up with the courts. Commercial rent arrears recovery, the normal position before pre-COVID was you had to have 7 days worth of rent in order to send in High Court enforcement officers under CRA. That was extended to 90 days, which struck me as being a slightly odd period because every quarter is at least 91 days. So extending it to 90 days really didn't protect tenants who pay their rent quarterly. So I think the government has now recognised that was an issue. They've extended that to 189 days. So that will now cover any 2 quarters of rent. So if the March and June quarter rent have not been paid, then the landlord cannot now use CRA. There would have to be at least 3 quarters due before that's an option. Lastly, there is some legislation going through Parliament about winding up and statutory demands. It seems likely that there will be restrictions imposed until at least the 30th of September. So I'll just hand you back to Andrew, who will just briefly run over the position in Scotland. The previous slide sets out the position in England and Wales, and there are a few differences if you have any properties in Scotland.
Thanks very much for that, Peter. So looking briefly at the position in Scotland, whilst generally RICS lease codes tend to apply in one jurisdiction or another, as Peter has said, this particular code applies across both jurisdictions. It's been endorsed by Scottish representative bodies, so as far as Scotland is concerned, I would really just echo the comments that Peter has made. That said, just to reiterate one point from the last webinar, Peter mentioned possible regearing of leases. So again, just to flag that there may be cost implications there where a lease is being extended and moving from the SDLT regime to the LBTT regime, which replaced SDLT in Scotland in 2015. And possibly that would happen where a lease is being extended without the benefit of overlap relief, given that they are two different regimes. So just ensure that that's factored in to what will no doubt be a discussion which is intended to save costs from the tenant's perspective. Turning to the position with irritancy in Scotland, which is the equivalent of forfeiture in England, the traditional position under the Law Reform Miscellaneous Provisions Act 1985 is that 14 days notice is required for monetary breaches. Under the Coronavirus Act in Scotland, that period has been extended to 14 weeks, and that legislation applies until 30th of September this year. That is, however, I think a slightly different structure from England. The legislation came in on 7th of April. So if a notice has been served, then it's possible that it would crystallise before 30th of September. So the moratorium is working in a slightly different way in Scotland. It may be that pressure from businesses will come to the fore to change that, particularly considering that in Scotland we do appear to be coming out of lockdown more gradually than in England. The government does have in Scotland a reserved right to make changes, so it's possible that either the 30th of September date could change or the 14-week period could be moved out to bring us more in line with the position in England. So that's something we need to keep an eye on in the coming weeks in Scotland. That's really all I have to contribute in terms of differences up in Scotland. It takes us on to the question and answer session with the panel. We have received a number of questions in advance of the session today, so I can turn to those first if I may, if we have time for other questions which have come in with that. The first question I have is actually two questions which are very similar. Firstly, do you think landlords and tenants will follow the code, given that it's not binding? And secondly, this code doesn't seem to have any teeth. How can it be effective? I'll turn to Peter first on that, given that there's an enforcement element to that question and how it sits. What are your thoughts on that, Peter?
Yeah, I mean, my experience is that most landlords and tenants are actually already doing the kind of things that the code urges them to do. Obviously, there are exceptions, and you get some who are simply issuing demands and not really being very cooperative. So I think, firstly, I think many people are complying with the spirit of this already. In terms of how this code will make a difference, obviously you're not going to be able to get everybody in the market to follow the spirit of it. That's not going to be possible. But you know, one change we've seen in the last few years is a lot of retail assets like shopping centres have ended up becoming owned by local authorities who clearly will really have to seriously balance, on the one hand, the need to collect in rent for public funds, and on the second hand, to comply with something the government is telling them to do, and which will also support businesses in their area. And I think, yeah, there may be some impact on banks as well, although this doesn't directly apply to them. Obviously, a lot of banks received support in the last recession, and you know, there may be a public image issue that if they're seen to not be helping, then that might not look good. And you know, we'll just have to see whether some lenders, you know, may in the next few weeks perhaps engage a bit more with requests from their landlord clients and you know, possibly help them be a bit more cooperative.
Thanks, Peter. And on the last webinar, Helena, you looked at the position from the perspective of the landlord. Do you have any particular thoughts on that, on those comments?
Well, I mean, I think, as Peter said, that the code is voluntary, but I think, many landlords from a reputational, point of view may want to be seen to be following the code. And, with regards, lenders, I think the code may give tenants the courage to ask their landlords for more concessions, which the lenders may, feel that they're under more pressure to consent to the landlord to giving those concessions. I mean, also, I think, looking at it from a landlord's point of view, if you do end up in court to court, may, in considering whether you've acted reasonably, look at, whether you have followed the code. So I think, landlords do need to bear that in mind, and also that the government, if they feel that landlords and tenants are not following the code, may be minded, to make it mandatory. But saying that, they threatened that with the lease code, and they've never made that mandatory. So we'll have to see what happens. But of course, the code, doesn't apply until June next year.
Yeah, and Matt, you were commenting with the tenants hand on last time round. Have you got anything in particular to add to the comments?
Really, I mean, everyone's sort of touched upon the real high level stuff about, yes, it's not binding, it does represent best practice. Obviously, they've consulted with all the right people to put this together. With my tenant hat on, just a couple of things to pick the bones out of what Pete and Helena have said so far. I think that if there's going to be this drive towards a collaborative approach, then just saying this is something we would like because we've just come out of a pandemic isn't necessarily going to cut it. I think there'll be a new drive and requirement for empirical data. I think that certainly in retail, various landlords and tenants have kind of played with this over the last few years. I think in order to have any sway to banks to cut the sorts of deals that we've just been discussing, I think the use of MI, which this isn't sort of necessarily groundbreaking tech, but it is, as has been sort of one of the hallmarks of the whole pandemic, new ways of working and new ways of doing things and finding things out have been accelerated as a result of what we've had to do. And I think this is another instance of that. There are some really good cheap tech solutions out there to help both landlords and tenants sort of keep a better handle and find out more about their own assets as well as their own trading premises if you're on the tenant side. And just sort of one more practical point from tenants, I mean, service charge. I think Pete mentioned the fact that, yes, we've got this moratorium on the collection of rent, but service charge, dare I say, there will be a few more conversations between landlords and tenants about what the service charge comprises, discussions around some of the softer services which are provided. If elements of the shopping centre are closed, for example, there might be one big deep clean, but are you expected to pay for ongoing maintenance and day-to-day stuff, which just doesn't apply in a pandemic? But yeah, the headline point is the collaborative way is absolutely where this is going and where, dare I say, it needs to go.
Thanks a lot. It's interesting. The next question I have is, it's maybe one step further down the road. There has, I think, been a perception that the moving of the date forward is, in a sense, just kicking the can down the road. And the question is, what will happen in October when the moratorium falls away? It's certainly in England, obviously, we've got a slightly different scenario in Scotland. And I think this feeds into the fact that this isn't just a landlord-tenant issue, and you've already alluded to that in some of the responses we've had so far. It's a landlord-tenant and funder issue as well, and obviously we have a high-profile issue which most people will be aware of, with Intu and the difficulties it's been facing. How do you see that panning out when we get to the point where the moratorium is gone? Maybe put that to Peter first.
Yeah, I mean, clearly the moratorium can't be permanent. It will have to come to an end at some time. So I think the sensible thing to do would be to assume that it will end on the 30th of September. Obviously, there's a chance it may be extended further until Christmas, but we don't know yet whether that will be the case. I would certainly assume that it will not be extended beyond September, and if it is, well, you know, I doubt it would be any more than one further quarter. So I think there will be a reckoning, and I think, you know, some landlords I speak to are quite understanding of you know, small businesses who are struggling, but when you get large corporates who aren't paying the rent and you know, seem to be jumping on a bandwagon and taking advantage, you know, some of them will be lining up to take action. So I think, you know, there will be some rent accounts that either have to be regularised by the end of September, or we could see quite a lot of action being taken.
Yeah, thanks, Peter. And Helena, in terms of landlords' position and particularly their relationships with funders, what are you seeing at the moment? Anything in particular?
Well, I mean, you know, I think, you know, it does, you know, just, you know, kick the can a bit further down the road. And I know, you know, a number of, you know, landlords, you know, have been disappointed, you know, by the extension. I think, you know, what is important is, you know, the relationship with your tenant, and I think it's looking at, you know, each tenant on an individual basis and looking at their track record, you know, asking for copies, you know, of their accounts, seeing what they can pay, and then decide, you know, on what action to take. If they were, you know, a bad tenant and they were, you know, so before, you know, COVID-19, you know, question, you know, whether you want them to remain as a tenant. So you may be minded, you know, to forfeit their lease. But if it's a tenant, you know, they've always been a good tenant and you think that they can, you know, survive, it's working, you know, with them and, you know, seeing if there are, you know, any rent concessions that you could agree, you know, to help. You know, an obvious one which springs to mind is monthly payments of rent, which may help a tenant with their cash flow. And going forward in terms of new leases, as we discussed in our previous webinar, it's likely that we will see, particularly in the retail sector, more turnover leases where there's a sharing of the risk between the landlord and the tenant.
And do you think, from the point of view of landlords, they'll be a little bit more concerned about the possibility that if they do decide to remove a tenant, there might not be another tenant to replace them?
Well, yes, I mean that is a concern. You know, it's very much you know, a tenant market, you know, at the moment, and you would have to consider the, you know, location of your property and whether, you know, you would be able to find an alternative, you know, tenant, you know, to take the property, because otherwise, you know, you then become, you know, responsible, you know, for the, you know, the outgoings of the property, and if it's an internal demise, for the upkeep of the interior and the service charge shortfall, of course, as well.
Yeah, and Matt, Helen mentioned there maybe a tenant's market now. How does that feed into?
Yeah, yes. Just one other point that Helena made, which was spot on in the context of renegotiating and looking at deals, whether that's a re-gear of an existing arrangement or leases done in the future, is turnover rents, which aren't new, but dare I say that's something that will have to be looked at in sectors which haven't historically looked at them previously. That in itself, as again we touched on in the last webinar, is something that is in existence, but hinges very much on the definition of what your turnover actually comprises. And of course, retail being an especially good example. If your order is fulfilled on your phone 50 miles away, what comprises the turnover? And I've seen all sorts of interpretations on that and different drafts of what the turnover actually comprises, so there'll be more of a focus on that. Dare I say, there's some talk about profitability in the context of some high street properties being the measure, and how that will govern the rent that you actually pay. How that will work, time will tell. The other point as well is that whilst, to go back to the original question to Pete, I think whilst we have the moratorium, of course, that's the moratorium as imposed by the legislation and the change to the legislation. If, as I think the code almost mandates, to the effect that it has teeth, you can do a deal and rentalize your arrears or whatever the agreement is that you have with your landlord just ensure that it's correctly documented, and that document has some teeth effectively, so that you don't get to the end of the moratorium period and that's it, all bets are off, and they go straight to court. If you can contractually agree between you to push that period out for the repayment, fantastic. You know, you can do that. That is still a contract between you and your landlord. So if you can do it, of course, you've got to be able to stick to it, but that could buy you some more time.
Yeah, I think looking at time, we've probably got time for one more question here, which again I'll put to all of you, which is the following: can I withdraw from my tenant's rent deposit? Maybe Helena, initial comments on that?
Well, absolutely. Yes, you can. And furthermore, you can then ask for your tenant, you know, under the terms of the rent deposit deed, to top up the rent deposit. And, you know, arguably, actually, if they fail to do so, that's a breach of the terms of the rent deposit. It's not non-payment of rent. So this hasn't been tested yet. But we think it is possible, if you were so minded, that could be a ground on which you can forfeit the lease. Also, I think kind of going forward in terms of negotiating new leases, that landlords will be looking to take rent, you know, deposits. So in an event of, you know, for example, a second spike or a future pandemic, that you are able to withdraw down from that rent deposit.
Thanks. Peter, any comments you want to add to that?
Yeah, I mean, it's an interesting point. I mean, firstly, yes, you can withdraw from a rent deposit, because none of the government's measures prevent the rent from being due. They only block certain methods of recovering it. So if you have a rent deposit, you can draw down on it. As Helena said, the tenant is almost invariably then obliged to top it up. Could that be a breach that entitles the landlord to forfeit? Well, if it is, you would have to, and it's not deemed to be an obligation to pay rent, then, which is something the courts would, I think, will be having to grapple with. You would, as landlord, have to allow the tenant a reasonable period of time to remedy that breach. So any landlords wanting to go down this route, I think, you know, it's almost even more important that they comply with the code and ascertain that the tenant has been given a reasonable period of time to make good that breach in all the circumstances.
Yeah, thanks. And Matt, finally, anything on that you want to add before we wrap up?
Not a huge amount, just to safe to say that if you're a tenant, you just might want to check which properties you do have rent deposits out on. Yeah. It would be pretty prudent at the moment, I would have thought.
Yeah, I think there's a bit of management required by everyone to ensure that they're well positioned going into the management of the lease code. Okay, well that brings us up to the point where we've run to our allotted half hour for this session, so I'll now bring things to a close. If there are any questions which have not been picked up during the session or which arise subsequently, please feel free to contact us via the contact details which are on the screen. So it just remains for me to thank the panel again, and to thank you for joining us this afternoon. Hopefully you will join us again on future sessions. So until then, thanks again and stay safe.
Thank you. Bye.
Bye.